All right. This past Thursday, a federal judge issued an arrest warrant for the Attorney General of the United States, Pam Bondi, held in contempt for evidence suppression. According to court documents filed in the D.C. Circuit, she personally directed the withholding of 847 pages of classified material. Material a grand jury first subpoenaed 11 months ago. $2.1 billion in transactions. 23 shell companies spanning 7 countries, all of it concealed until Wednesday night. I've been reviewing this filing for 6 hours. I just finished my 3rd read-through. Here is what I uncovered. And here is what every major news outlet is either overlooking or afraid to state openly. The documents are now public. Let me guide you through them. A quick background. Pam Bondi, former Attorney General of Florida, appointed U.S. Attorney General early in Trump's 2nd term. The core issue, a federal investigation into foreign financial transfers connected to entities with direct access to the White House. The investigation began under the prior administration. Bondi inherited it. What transpired next is now the subject of a federal case. Here is the timeline condensed. Shortly after assuming office, Bondi reassigned 3 career prosecutors from the case, transferring them to unrelated matters in different districts. Months later, the lead investigator filed an internal complaint, alleging documents were being diverted away from the grand jury. Weeks after that, a whistleblower approached the Inspector General, providing backup copies. Then, late last year, a federal judge ordered the DOJ to produce all withheld materials within 60 days. Bondi's office missed the deadline twice, requested for extensions, and was granted 2. Then came Thursday. Judge Eleanor Matsumoto of the D.C. Circuit did not request, did not suggest. She ordered an arrest warrant issued for the sitting Attorney General. An unprecedented event in American history. That is the context. Now, the documents themselves. Let's examine the evidence. The first document was filed Wednesday. I turn to page 34. It states, and I quote, "The respondent engaged in a deliberate pattern of noncompliance designed to obstruct lawful judicial process." That is not my interpretation. That is Judge Matsumoto's finding. What it signifies is that the court determined this was not mere bureaucratic delay. It was intentional. But here's what caught my attention. Page 112, a different section entirely. Internal DOJ emails obtained through court order discovery dated 14 months ago. One email from Bondi's chief of staff to the head of the criminal division. The phrase used was slow walk protocol. Not my terminology, their terminology. Connect those dots. It indicates coordinated suppression. I examined this 4 times. The pattern is unmistakable. Financial records from a Cayman Islands subsidiary linked to a Nevada LLC. $340 million was moved within a 90-day window. Internal alerts were raised by DOJ career staff. 3 separate memos recommended immediate escalation. Each memo was disregarded. 2 were returned with handwritten notes stating, not a priority at this time. All of this is documented. Exhibits F through K. Now, the detail that no one is addressing. Page 203 in the appendix section. A series of signal messages recovered from a backup server exchanged between Bondi and an unnamed White House official. One message timestamped 11:47 p.m. on a night 15 months ago. POTUS aware. Holding until after midterms. Read that line again. If it is authentic, and the court has certified these under penalty of perjury, this fundamentally alters the situation. We are not discussing bureaucratic inefficiency. We are discussing a coordinated effort to suppress material evidence connected to the President of the United States. The grand jury was investigating financial transfers, shell companies, and offshore accounts. Some of those entities held contracts with agencies inside the executive branch. What the documents reveal is $2.1 billion moved through 23 entities across 7 countries over a 4-year period. 19 of those entities were flagged by FinCEN as potential money laundering fronts. 7 had direct or indirect ties to foreign nationals with no legitimate U.S. business presence. And all of this information was supposed to be presented to a grand jury. Instead, it sat in a DOJ vault for 11 months. The whistleblower, whose identity remains sealed, provided 847 pages of supporting documentation, emails, internal reports, calendar entries, and meeting notes. Judge Matsumoto reviewed them in camera, meaning privately, without public access at the time. Her conclusion, stated on page 4 of Thursday's order, the evidence presented demonstrates a sustained and coordinated effort to prevent material facts from reaching the grand jury and ultimately the American people. That is a federal judge speaking, not a pundit, not a partisan, a George W. Bush appointee, for what that's worth. The fallout: the arrest warrant was issued Thursday afternoon. U.S. Marshals were instructed to take Bondi into custody if she fails to appear by Monday at 9 a.m. An emergency motion filed by the DOJ late Thursday night was denied within 3 hours. Within 72 hours, we went from sealed records to an arrest warrant for the nation's top law enforcement officer. That is our current situation. And that is merely the first layer of the documents. I am still working through the appendices. If detailed breakdowns like this are valuable to you, consider subscribing. I am covering this as it unfolds, not after the pundits tell you what to think. However, we must be balanced. The opposing side raises valid points. A few, in fact. DOJ defenders and Trump allies argue this is judicial overreach, unprecedented, and politically motivated. And honestly, some of those arguments hold weight. Their case rests on several points. First, executive privilege. Bondi's legal team argues that communications involving the president are protected and that a federal judge cannot compel disclosure of internal executive deliberations without clear evidence of criminal intent. Second, the timing. This ruling came down 11 days before pivotal congressional testimony on DOJ funding. Critics argue this is not a coincidence. Third, and this point has merit, no sitting attorney general has ever been held in contempt and ordered arrested, ever. There is no precedent for this. Jonathan Turley, constitutional law professor at George Washington University, stated it this way: this order raises serious separation of powers questions that will likely reach the Supreme Court. I don't agree with all of it, but that argument cannot be dismissed. Executive privilege has been upheld in prior cases involving White House communications. The special counsel statute expired years ago. There is ambiguity regarding the scope of judicial oversight over internal DOJ decisions. Even Alan Dershowitz, no proponent of judicial restraint, admits the constitutional implications here are murky at best. Look, I am not here to dictate who is correct. From one perspective, Bondi's team has a legitimate institutional argument. The executive branch has long maintained that internal prosecutorial decisions are shielded from judicial review. There is case law supporting that view. From another perspective, the documents reveal a pattern that strongly suggests deliberate obstruction. And when 847 pages are concealed from a grand jury, pages that involve billions in foreign transactions, that is not a gray area. Both perspectives can hold truth. That is what makes this situation complex. There is also the political context. Bondi was a Trump loyalist before becoming AG. She defended him during his first impeachment. She campaigned for him. She was one of his earliest legal surrogates. Her defenders argue that is irrelevant. Her critics say it explains everything. What I can tell you is what the documents show. They show that internal DOJ staff repeatedly raised concerns about evidence being withheld. They show that those concerns were disregarded. They show that when a judge finally demanded production, the DOJ stalled for nearly a year. You can interpret that as bureaucratic inefficiency. You can interpret it as something more deliberate. But the judge, after reviewing the sealed evidence, arrived at a finding of contempt, not a warning, not a fine, but an arrest warrant. That is not a decision made casually. And the fact that legal scholars on both sides are calling this unprecedented indicates the magnitude of the stakes. This is not solely about Bondi. It is about what the executive branch can and cannot conceal. That is what makes this situation distinct. This did not emerge suddenly. Here is the background, briefly. Over 2 years ago, the DOJ opens a financial crimes investigation. The targets were unknown at the time, handled by career prosecutors in the public integrity section. Approximately 18 months ago, Bondi assumes the role of AG. Within her first 60 days, 3 senior prosecutors on the case are reassigned. Roughly 14 months ago, the lead investigator files an internal complaint. It alleges key evidence is being misdirected. A year ago, a federal judge issues a subpoena ordering the DOJ to produce all relevant materials to the grand jury. Shortly after, the first deadline is missed, then the second, then the third. The whistleblower, whoever they are, approached the inspector general sometime in the middle of all this. Someone inside the DOJ even stated on record in a deposition later unsealed, there were instructions, not written, but clear. What occurred after that? Silence. Officially. Unofficially, leaks began to surface. Reporters obtained fragments, pieces of emails, references to offshore accounts. Then last month, Judge Matsumoto's patience ran out. Pattern. Evidence was flagged, evidence was rerouted, complaints were filed, complaints were ignored. Every single time. Delay, extension, reassignment. Until Wednesday, when the full 847-page whistleblower file was finally made public. Do you see the trajectory? If this breakdown is making sense so far, please hit like. It may seem like a small action, but it helps more people see the complete picture, not just the headlines. More information is coming. Stay with me. Thursday, 2:14 p.m. Eastern. Here is exactly what transpired. Judge Matsumoto issued her ruling from the Barrett-Prettyman Courthouse in Washington. There was no warning, no advance notice to counsel. She read 16 pages in full from the bench. The Attorney General of the United States has demonstrated willful contempt for this court's authority and for the rule of law. The courtroom fell silent. Reporters later noted that no one moved. What followed? The arrest warrant was signed and transmitted to the U.S. Marshals Service within the hour. Bondi's legal team filed an emergency stay, which was denied by 5:30 p.m. The White House issued a one-line statement calling the ruling politically motivated. 3 hours. That is how quickly it happened. Now, here's what everyone overlooked. While the press focused on the arrest warrant, something else occurred. The court unsealed a second filing, a shorter one, 14 pages. This one was not directly about Bondi. It referenced a parallel investigation, one that appears to involve financial transactions from the same offshore network, but routed through a different channel, a channel connected to a sitting member of Congress. No name has been released yet. The filing only refers to Legislator A. Then, late Thursday night, a second whistleblower came forward. This one is inside the Treasury Department. Judge Matsumoto ordered that testimony sealed. However, the motion to seal was itself made public. And within that motion, there is a reference to documentary evidence involving the executive office of the president, not the DOJ, the White House. The judge's response, a gag order effective immediately. No public comment from any party until the Monday hearing. This was not a reactive measure. This was sequenced, legally coordinated. You can see it in the timestamps. Filing at 4 p.m., seal at 4:12, gag order at 4:47. Someone anticipated the backlash. This is where the situation becomes particularly compelling. Don't go anywhere. What I am about to show you next will reframe the entire scenario. Drop your prediction in the comments. Do you think Bondi will appear on Monday, or will this go to the Supreme Court first? Let's see who is paying close attention. What are the experts saying? A former assistant U.S. attorney for the Southern District of New York, with 22 years of experience, now in private practice, stated, "This isn't just about contempt." The court's language signals it believes a criminal referral is appropriate. In plain English, Judge Matsumoto may be setting the stage for prosecution. Another expert, a former deputy attorney general under Obama, commented, "The arrest warrant is extraordinary, but what concerns me more is the second filing.